Thank you. Colleen will be appearing by phone, as I think you know. Okay, the Court of Appeals is now in session.
Good morning, everyone. Welcome to the Court of Appeals today. We appreciate you joining us and accommodating this slightly earlier setting as well. Let's go ahead and have counsel just make their appearances for the record. Ms. Coburg, why don't you begin?
Colleen Coburg on behalf of the appellant.
Thank you. Mr. Peterson?
John Peterson on behalf of the state of Utah.
Thank you so much. And on behalf of the guardian?
Dixie Jackson, guardian ad litem on behalf of AH and NH, Your Honor.
Okay, thank you to each of you. Ms. Coburg, it looks like you've reserved 7 minutes for rebuttal. Is that right?
That is correct, Your Honor.
Okay, perfect. And can you see the clock, or are you going to kind of track your time on your own?
I can see it front and center. It is counting down for me.
Okay, perfect. And Mr. Peterson and Ms. Jackson, are you planning to both argue today or just one of you?
We'll both be arguing and we'll be splitting the time, and Ms. Jackson will go first.
Okay, perfect. Thank you. Just to give you a little bit of a heads up, things usually work pretty well in this format, but if we do have any glitches, we will, of course, just pause the proceeding, make sure everyone is hearing and seeing everything they need to see and hear. If for some reason we talk over each other or you don't hear a question, please just ask us to repeat it. I know sometimes there is a little bit of feedback or a little bit of overlap in this kind of format. What else? We are recording this and live streaming, so just like we would be in the courtroom, people may be listening and watching, and it will also be available recorded on our website after we are over today. The other thing I'll ask is that everyone mute their microphones when they're not speaking, just so that we don't have additional feedback. The judges will do the same. And if the judges have questions, we will try to kind of raise our hand just to give you a heads up that we would like to jump in there. If we catch you mid-sentence, please feel free to finish your sentence. We just want you to know that we do have a question before you move on to your next point. Also, if you're not arguing, if you'll turn off your camera as well, just so that the person that is making the argument can be the focal point of the argument. So any questions anyone has before we get started? All right, seeing none, I'll turn the time over to you, Ms. Coburg.
Thank you to the court, and thank you everyone for being so gracious as to move this argument so that I could better handle getting to my son's graduation at the U. I really appreciate the courtesy. I'm here to argue the case for my client, KH. I was not trial counsel below. I am frequently trial counsel below. I want the court to know that I have argued my own ineffectiveness before, as we are required as child welfare parental defenders. I've argued that it doesn't make sense for us to have to argue our own ineffectiveness, and I've been quite ineffective at arguing my ineffectiveness. But today I have the unenviable task to present to the court an issue of another attorney's ineffectiveness. And I would like to point out, as a practitioner in this area, that it is frequently mistaken for family law. We sometimes see practitioners of family law coming into our little playground and thinking that it's essentially the same, that custody issues are similar, and they are not. It's in the Child Welfare Act, and the activities governed, or DCFS's activities generally are governed by 62A 4A 101 at SEC. It's a different area of the law. It is similar to thinking you could do a lawsuit between two private parties, or you could just as easily go before the tax commission. Entirely two different animals. And in this case, my observation, having studied the record extensively, is that counsel, as he admitted, did not know this area of the law. I pointed out in my brief numerous citations where he himself told the court, I do not know the rules. I don't know the rules that apply. I have provided a citation to the record for the court that he indicated that He did not know the burden of proof. And that is a significant issue. And probably one of the more significant issues is in this unusual area of the law, there is almost, when you have a termination case, it is almost 100% of the time that you have a prior adjudication on an initial child welfare petition that will absolutely, it's set in stone by that time. This attorney believed that basically he could relitigate. And if not that, he was completely mistaken about the status of the case. And I say that because I have also provided you a citation to the record that on the 4th of 11 trial days, the 7th of 11 trial dates, he very oddly states to the court, I want to put on the record that I do not have a copy of the petition that we are here to try, which is absolutely categorically, in my mind, ineffective, inexcusable. Yes, Your Honor.
Well, I think you're quite accurate that in the area or the arena of child welfare cases, we do not entertain ineffective assistance claims with overwhelming frequency. I think that's probably accurate. However, ineffective assistance claims in general are somewhat of a bread and butter issue for this court. And so I don't know about my colleagues, but I hope that you'd use your time here this morning to link up for us specific actions of counsel. Why, and I think you're getting to why they're objectively unreasonable, maybe, but more importantly, far more importantly to my mind, would then be the link of prejudice. The allegations in the opposing briefs are that prejudice really was not explored. And I think you need to show prejudice in that you need to show that what counsel did or didn't do resulted in something happening that shouldn't have happened. And even more than that, how it affected the ultimate outcome of the case and how it would be different had that not have happened. Do you understand my question?
I do, and I appreciate the clarification. First off, not knowing the burden of proof and not knowing that the initial findings were set in stone led to a catastrophic series of events that utterly crippled the defense in a case that otherwise was absolutely phenomenal in the fact that the juvenile court knew, and there were allusions numerous in the record, that my client had had an afterborn child, that he had actually obtained custody of that afterborn child. And the reason that that is significant is that the attorney's misunderstanding about the basic tenets of child welfare law, that the initial findings were set in stone, and the whole idea that he thought he could relitigate, or that it was even a good idea to relitigate the initial findings, completely got the defense off onto a tangent where there was not sufficient focus on the fact that the father, my client, had attained the status of a proper parent. And that was while he was fiddling around with calling the ombudsman about the kinship placement, which the court had to tell him was irrelevant under case law he didn't know, and trying to back out of the initial findings, he paid virtually no attention to the fact that the present fitness issue reflected that my client could have a defenseless little baby with him, but he was not focusing on the fact that he's attained present fitness. He has a baby with him. The court has allowed him to have a baby with him, and that is the prejudice.
So, Ms. Colbert, let me just ask a question about that. I mean, the court clearly understood that, right? He understood the kind of the unusual situation here where he was allowing the father to proceed with this infant. But but he stated several times on the record that, despite the father's ability to rehabilitate himself to some extent, his actions had destroyed the parental relationship with these children to such an extent that the rights should still be terminated as to those children. So despite counsel's shortcomings, it seems as though the court was really focused in the right place, wasn't he? Didn't he understand the distinction between the situation with these different children?
And, I appreciate the court's observation, and that's, that is certainly a point in the record. But I think the issue is when counsel is so seriously misguided on the law and off focus, you can say, sure, the court knew that was the end result. But if that was the case, that the court would know the end result in a child welfare case, we wouldn't have to have termination trials. That's why effectiveness of counsel matters, that you actually hammer away at those issues. And that's why I added the issue about the phraseology of not a model parent in the statutory code, because it is my observation that once a parent gets into this forum, that concept, not a model parent, completely gets lost. There are parents that are less than optimal. I'm one of them. I could have had all 3 children removed, and if they weren't 35, but it is not required under the Child Welfare Act that a parent be perfect. And so that is why the focus needed to have been off of these red herrings that counsel got involved in, because he simply did not understand. And I would like the court to recognize that at a certain point, that the errors and deficiencies of counsel are so pervasive that the court really should consider whether, as a whole, that my client had a fair day in court. And if there ever was a situation, this is the one. He had the appellant point out how much he paid him, which then led to a finding that that he willfully failed to pay child support. In no universe could there be a strategic reason for that. And I'm sorry, I ignored you and kept running my mouth. I apologize, Your Honor.
I just was hoping you could address what do you believe a competent attorney would have done differently, and how would that have changed the outcome here? I understand that you think that they should have focused on the present fitness. I understand that, but why would that have changed the outcome given the court's findings?
I think it would have changed the outcome because there would have been an entirely different focus. I think with an 11-day trial, with those pervasive errors, and without the focus being on present fitness, there was simply insufficient evidence presented, and it isn't sufficient to just say, well, you know that, Your Honor. And you look at how much time was spent spinning his wheels and actually injecting matters that the court could find against the father, versus making the argument. And it was, I had had 2 appeals. I'm sorry, I hope I'm not misquoting the record. But I do believe that Judge May, in his very extensive findings, did point out that the father had made great strides. And so if that focus had been appropriately and effectively handled, it could have changed the result in this highly unusual case where the appellant actually had his child back. We don't see that. We don't see that proverbial splitting of the babies. And so this was an incredible situation for counsel that actually was more conversant in how to run these trials, to have capitalized on that, rather than basically softball findings for the judge to find against the appellant. And I would hope that the court would review the matter, find the deficiencies of counsel so pervasive in this area of fundamental constitutional rights, as to grant this father a new trial with a constitutionally and statutorily effective attorney. And I'm way over my time. And I suspect the clerk will have adjusted me appropriately.
Well, we kept you answering some questions, so I think we'll give you your rebuttal time. Let me ask one more question, just so I make sure I understand your third issue. In response, I think there's some understanding that you're making a sufficiency challenge in that third issue. Is that fair, or what is exactly you want out of that third issue?
I guess it would be a sufficiency challenge, but also an invitation for the court to consider that phraseology of the not a model parent has never been fleshed out. And in my view, in dealing with the people that I deal with, there are people that live next door to you and across the street and perhaps in your own house that end up being worse parents than people in this forum that get terminated. And that phraseology was not adopted by the legislature to be ignored. And yet, I've had years worth of jurisprudence that ignore the concept. Where is the line in this area where the juvenile court gets tremendously broad discretion? Where is the line where you cease being merely not a model parent and someone who deserves to have their parental rights terminated? The legislature did not define that. It is up to this court to give it structure and meaning.
Let me ask one more question with regard to that. Does that term just relate to the standard of unfitness?
No.
Or are you contending it somehow covers all 5 grounds for termination?
All of them, because if you recall where it is found, it's in the preamble to the Child Welfare Act, and it is specifically stating the state's principles related to the protection to be granted to a parent's fundamental right to associate with their child and to rear their family. And so it is an overriding principle that would apply to all terminations of parental rights.
All right. Thank you, Ms. Kober. We appreciate the argument. You'll have your time on rebuttal. Ms. Jackson, I believe you were going to go first.
Thank you, Council and Your Honors. Hopefully you can hear me okay. Perfect. I think first what I want to do is clarify that's happened today as far as what the facts are. At the time of trial and all the way through trial, the father had not regained custody of the infant, this third infant. He did not regain custody until the conclusion of the trial because the court, after hearing all of the evidence, said, while I find that you are not able to, or while you're unfit and you haven't remedied the circumstances with regard to these 2 children who were on a different timeline, I find that you've done what you need to for this child who's on a different timeline and you're still within the period. So just to clarify, he did not have custody of that infant during the case. He didn't have a trial home placement until after trial, none of that. So he didn't have the parental presumption back. And I think that's very important for this court to know. But I think what this case really boils down to is the fact that fitness and permanency specific to the case and specific to the child. This particular case involves 2 special needs children who had already been out of the home for a significant period of time. The father waited till almost a year into the case to show any interest in these 2, and that was after the afterborn child was born. So these 2 children, and I think that father's argument kind of shows a real insensitivity to these 2 children and their situation. It shows an insensitivity to their impermanency that they had experienced in being removed, being in a placement for quite a while, having a trial home placement with the mother disrupted, being again in the foster home because the father didn't do what the court and people requested him to have a trial home placement. He didn't provide any of the information that was needed. The trauma and neglect that they had experienced throughout their lives, which is very different than what the afterborn child experienced. And so we need to look at the fact that these children were on a different timeline, had withstood those different adverse childhood experiences, and had little or no parent-child relationship with the father. Okay, so that does make this case different than the after-born child. And his 11th hour efforts, whatever you want to call, right? When we look at present fitness, we have to look at what those 11th hour efforts or what that present fitness is. And the court has a duty to look at present fitness and consider that in light of the past conduct and the debilitating effects on the parent-child relationship. Right? We have that in XRL DH 2005 Utah Act 210. And so when we're looking at his present fitness claim, I don't think that it does make a difference in the outcome. And the court addressed that. We certainly addressed at trial the relationship between the father, the child's special needs in these cases. Everything that the court made and all of the evidence that was put on was for a present fitness defense. Yes.
I do have a question about the court's reasoning with respect to the special needs child. And it's just for my own clarification, because there, of course, is this language in the statute saying that, parents don't have to be model parents. But the court did talk about how one of the children needed highly skilled parents, and that neither parent had the ability to provide those types of the type of care that child needed. How, is that a legitimate consideration? I mean, if you have a child who needs highly skilled parents, does that change the bar that we're setting for what the parents have to show?
Well, I think that what we're saying is that, again, fitness is specific to the child, right? And so, yes, I do think that in certain cases it changes the bar only in the fact that he needed to do extra to be able to parent this particular child. The only extra we asked him to do, of course, was parenting classes and parent-child interaction therapy so that he could learn to engage with the child. And while he wasn't able to finish that parent-child interaction therapy because he didn't start working on it until late in the case, that therapist who was providing that therapy said he doesn't get it. He doesn't get that he needs to how he needs to parent this child. He doesn't get the fact that he treats the 2-year-old as if she is 4 and has those expectations for him. And that certainly is relevant to whether you can return a parent safely to a child or not. The AH, the one that he's talking about, in his neuropsych, it indicates he will need 40 hours of intervention per week, most of which is put on the caretakers to provide because the school district can't provide as much. A court can't ignore that when they look at, how are we able to take care of this child and can he safely be taken care of with the father? And so I do think that the other thing that you look at is in Re CJ 402 P3rd 27, it says the standard of parental fitness may vary depending on the needs of the child, specifically outlined in that case.
Thank you. That's very helpful. And one other question for you. Since, of course, as you know, we only have to find that one ground for termination is supported by the record. I'm just wondering if you think that subsection F, the providing only token efforts to support the child, independently supports the grounds for termination apart from all of these other parental fitness considerations, or the ability of I'm sorry, is it KH to parent these children?
And so when you look at the token efforts, I do think that there was enough to independently do this. Not only did he make token efforts to take care of the child and provide for them by getting parenting, by getting appropriate housing, by letting us look at that housing and stuff like that in a reasonable time so that we could try to work towards a placement with him. But also, whether they testified about it on the record or not, it would have been brought out that he was paying trial counsel and yet had paid no child support, had not done any of those types of things. And I do think that him not addressing each of the grounds of termination is a real big issue. But if you look at them independently with the facts, the extensive facts in this case, you're going to find that there are grounds for that as well. Other questions so far? Okay, so I do want to also address, I think
Ms.
that,
Jackson, I
yes,
apologize. Before you move on, can I take you to a different spot of the argument? But one of the arguments that's made has to do with making reasonable efforts towards reunification. And in your brief, there was some statements made about father not making objections while the service plan was ongoing. I'm just wondering if you think that means that he somehow waived arguments regarding the service plan and the efforts that were made, or if it's still appropriate for him to make those arguments at trial.
so I believe it's per our case law and stuff like that, a parent can bring up a reasonable efforts argument at any time during the case. What I'm saying is it doesn't make sense. And I think he does waive certain arguments when he comes to the end. Because if you're going to wait until the appellate court to say, you should have given me this, there's no way that anybody was on notice to even address it. But Dad's argument is that we should have provided PCIT earlier. The problem that we have is that when Dad took his parenting class, it showed he didn't get it. Not only that is, in order to do PCIT, you really have to be able to have more time with the child. So he needed to work to a place where he could have more time with the child rather than less as far as supervised time and stuff. And he never progressed that far because he hadn't finished treatment. He hadn't finished his psychological evaluation. He was still working on anger management issues. And so it's a parent, if you look at that, right, to make sure that they do their part of the service plan to move forward. I do think that while it's allowed, I think if you look at, sorry, let me get my citation up really quick. The National Council of Juvenile and Family Court Judges Enhanced Resource Guidelines from 2016, it's going to say that it makes no sense to wait until termination to do so. But you also have some cases, I think, that are relevant to him bringing up as untimely ejections. And I think that's In Re ER 2001, Utah App 457, and In Re AL 2008, Utah App, and I have 457, so I may have the wrong page number on that. I'll fix that in a 24J. And then In Re KF 2009, Utah 4. I think if you look at those, that it's going to say, yes, you can do this, but it also can cripple your case if you wait clear until the end to bring up a problem that you had. The other thing that I would say is it's inappropriate to raise appellate claims going to division error rather than court error, right? The issue should be, the argument should be that the court erred in finding, these reunification services, but what they're really arguing is that DCFS erred in not providing the PCIT, even though there was a motion filed to continue PCIT, which was heard and denied. So I think that at this point in time, arguing the division should have provided something that the court had denied could continue is kind of useless.
All right. Thank you, Ms. Jackson. Appreciate your argument. Mr. Peterson.
All right. Am I on? Yeah. May it please the court, John Peterson for the state of Utah. It seems, listening to the questions from the court so far and counsel responses, it still seems to me there's everything in this case really comes down to the fact that Father KH just simply dragged his feet, did very little for basically the first year of the case, and coming into termination, all he really had was to try and blame somebody else. He can try and blame the court. He can try and blame the division. He can try and blame his appellate count or his second trial counsel. But at the end of the day, what really comes down to is that KH just simply showed a marked reluctance to do much of anything in this case until it was just simply too late. And I know Judge Hagan asked whether it amounts to token efforts, and I think it very much does, but I think it also amounts to, unfitness under the BR test. And he's trying to claim he's presently fit because he has the baby AMH with him. But as the court explained, this is a young child who's been able to be placed with him almost from birth. Look at NH and AH, on the other hand. At the time of this case started, they were 2 and 4. They're now 4 and 6. NH in particular didn't even hardly know who KH or who Dad was at the time of removal. He wasn't really the hands-on parent. It was mom, and he sat back and he thought that mom was going to, turn herself around and become mom again and do everything. And he did nothing. He didn't even start drug testing for 9 months. And when he starts complaining that, well, you should have been doing, PCIT and these extensive therapies with me, they weren't even the point of like doing overnight visits or doing much in the way of visitation at all, because he hadn't even started the basics of his program. And he was fighting with people, yelling at people, swearing at them, behaving badly. He was not, really working very hard. By the time of termination, yes, is at that point, if he'd been that person at time of removal and he had been fully engaged, this would be a very different case. But yes,
but I suppose that goes to the question I posed to Ms. Jackson is this all goes to some of the other grounds for unfitness, but it doesn't seem like he had remedied at all, even belatedly, the token efforts to support the children. He still hadn't provided any financial support for these children. If that's the case, then why wouldn't we simply affirm on that ground? And it doesn't appear to me that an argument has been made that the best interest analysis was flawed. I'm just not sure, why do we need to reach these other grounds regarding failure of parental adjustment and failure to remedy and neglect and all of those things?
I don't think we do. I'm happy for the court to affirm on any basis. We try and be comprehensive and address and give various avenues, but and certainly, I think token efforts fits. And that also means it's very well given. Just that initial 9 months. 9 months in the life of a 2-year-old. By the time he gets up to the point of saying like I'm a good parent now. NH doesn't even know who he is. AH certainly knows who he is, but he's no longer the person that AH trusts or that NH knows anymore. And AH is a special needs child for sure. He's on the autism spectrum, that was clear. And both NH and AH have other problems that were frankly caused by the parents and by the neglect they've experienced, like the trauma of neglect. NH's problems aren't as severe, they aren't as biological, as inherent as AH's problems are, but they're definitely there. And I know, Judge Hagan, you asked about like this, whether there was a different bar. At the end of the day, a parent has to be able to care for the child they have. That's simply all there is to it. If you can't, whether that's maybe you're a parent who has physical limitations and you can't lift the child. If you can't care for your child's needs, you can't care for your child's needs. And some children have greater needs. Some children need to be placed in the state hospital. And we've had cases where DCFS has intervened because parents refuse to get the kind of medical treatment they need. And that's just a failure of doing it. But at the end of the day, if you can't care for the needs your child has, then you're not an adequate parent. That's the CJ case that Ms. Jackson cited in my brief as well, and actually relied on by the trial court. I would note that the trial court did a very good job of relying upon case law, BR, CJ cases, and supporting its decision. And I think the court's analysis was excellent and obviously quite extensive in this case, a bit more extensive than you might even see in many cases. But I appreciate that, and I'm sure the court appreciates the court taking the time to explain its decision, particularly given that, as the court even recognizes, it is odd to say, okay, I will put the baby in your care, but I'm not going to put these older kids in your care. Because typically people think, well, the baby is probably a little more difficult, but it really is a relationship question. It's not end of the day, father probably could care for a 4 and 6 year old if those kids knew him, but they don't. They look at the foster parents as the only real parents they've ever known. They've been with them now since October of 2017. That's their familial identity. And the reason why they've been with those people is because their parents failed them early on and throughout the case. I think Mr. Jackson did a good job with the facts. She was obviously trial counsel, and she knows this case backwards and forwards. I appreciate her being here. And if there aren't further questions, I will leave it to the court for decision. Thank you.
Thank you, Mr. Peterson. We appreciate it. Ms. Coburg, you have your time on rebuttal.
Thank you. One thing I'm always concerned about in these situations is engaging in hyperbole that makes these situations seem more black and white than they actually are. I listened to the statements of my esteemed counsel. I have tremendous respect for both of them, and yet the language used, that father did nothing and NH didn't know him and things of that nature, I think are very dangerous extremes, in that they do mislead to the point that if the court were to adopt them, it would be embracing a state of fact that did not exist. The father was active throughout this case. He visited consistently. He was engaged totally in the interactions between himself and his children. Every week, he saw the children. And I'm very concerned about the suggestion that if the children recognize someone else as their primary caregiver, then the parent is unfit. There are numerous reasons why that could occur. That could occur even in circumstances where, say, the father lives in Kansas, or the parent that isn't DCFS involved, or a quote unquote at fault, neglectful, or abusive parent has not allowed contact with the non-custodial parent. The whole process is to reform the relationship. And it was the court's finding that the father had not succeeded in completing his service plan. But that's what reunification services are for. The court also, as it related to PCIT therapy, made its own finding that could have been supplied earlier. The court then said, I'm finding that it doesn't make any difference because the PCIT therapist said that it wasn't working anyway. However, again, the focus in this case has to be the present fitness. And if this court adopts the proposition that, well, the dad, wasn't doing what he needed to do the whole time, and NH, particularly the younger one, didn't view him as primary caregiver, and that relationship hadn't developed to the degree that everyone felt comfortable about, then forget about it. And it's either one or the other. It is either that present fitness is a real concept that has meaning, or that that it was a foregone conclusion that because he didn't have that relationship and he was working on it and it hadn't been attained, then he was unfit at all times. That's what I understand counsel's argument to be. And it is a very dangerous argument in this realm where the whole purpose of, and all you guys ever hear is termination cases. The first words in the Child Welfare Act are how we value families being together. And we also end up in these oral arguments talking about, well, you need to be able to take care of your children. You need to be a good parent. You need to this and that. Again, that raises the bar for persons before this court. We're not talking unfitness now. We're talking you just need to be a really good parent for this kid. You need to be the kind of parent this child needs. That is not the standard, thank goodness. Or we would all be subject to parental rights termination at some time in our lives because our parental qualities and resources can fall short for any one of our children at any time based on our resources, based on their need. And again, I ask you to consider the concept that KH fails to be a model parent. He does. I do. You might. Anybody could. And I would ask that you consider that. Additionally, I want, Your Honor, Justice Hagan, You have repeatedly addressed the issue of token efforts, and I would remind you are finding that significant. I appreciate your thought process. Do not forget that the evidence related and the finding about token efforts is exclusively based on the ineffectiveness of counsel. He brought it up himself for no reason, no strategic, imaginable, competent reason would retained counsel bring up how much he was paid. Not once, 2 times. How much did you pay me? Did your mother pay me? Oh man, that's a lot of money. It led to the finding about token efforts for failure to pay. Inexcusable. And that you are requesting or information or considering that you could affirm on that basis that was invited for no strategic reason makes my point about effectiveness of counsel. In this incredibly important area, the most important area of human life, our association with our children, it keeps us alive. It gives us a reason to live, to get up in the morning, to keep going. This process cannot be affirmed with counsel that was so misled, so misguided, so ineffective. This court cannot trust that process. And my client deserves a fair trial. That's all he ever asked for, is a fair trial. I would request that you remand this matter so that he can have a retrial with effective counsel. And thank you again for allowing me to go early today. I'm sorry, Your Honor.
I'm just wondering about that last point. So we vacate and remand for a new trial. Where does that get us? Just focusing only on this token efforts. I didn't see anything in your brief that there's anything in the universe of facts. I understand your argument that the counsel brought this up, but what's going to happen on remand? I saw no indication in your brief that, number one, what was relayed at trial was inaccurate, or perhaps more importantly, that there's additional information that would put that in context, or in a different context or a different way that it could be argued. How is that going to change if we give a new trial as to token efforts for the payment of child support?
Well, Your Honors, I think that is a really tough question because it would be inappropriate for counsel to suggest in their brief what the present state of fact would be. And so how would that change for a new trial? I don't know that would be appropriate for me to tell you, well, my client is doing great. He's fully employed. He's, still seeing the kids, whatever. I don't think I can do that. But, it is a central problem in this case is that, bonding and et cetera, attachment to the kids is always argued the first go round. And even in those rare occasions that we win a new trial, you're basically focusing on the problem that would be before counsel. But I guess my concern as being a practitioner in this area is that we cannot solve problems of fairness in this very important area by just saying, oh, what's the use? You can be the protectors of this important constitutional liberty by ensuring a fair process. And so
I appreciate the idea of fairness, and I think it's really important. On the other hand, when you tee up an issue of ineffective assistance, where we have to, the logical legal analysis has to end up with prejudice, I can't see a more fair question than what difference would it make. I understand the position that puts you in, but if you're going to tee up the issue as sufficiency, that's one thing. But if you're going to say ineffective assistance of counsel, where you have to go through or have to address a prejudice prong, I think it's very difficult to stay away from asking the question, how would it be any different?
Well, and I think in an 11-day trial where so much of the time was diverted to not only increasing the prejudice against the father, but wasting time under circumstances where, again, this was a unique case in that the court had already authorized movement of an infant, a helpless infant, and the court had acknowledged there are many incidents in the findings where the court acknowledged the strides and the development of the father and his sufficiency for the youngest child, and where the ineffectiveness left the defense so off focus that because it is in the juvenile court's discretion, that had those errors not been made by counsel, that the court likely would have rendered a different decision. This, of course, when the court issues findings terminating, they draft them so that you will affirm. They draft them so that they're sufficient and bulletproof, for lack of better terms. But this was not set in stone, and the court acknowledged that the father had made great strides. And he had completed his service plan, but the PCIT therapy that he could not complete because of reunification services being terminated. That, with the court saying it could have started sooner. This, of course, when you're looking at the findings, doesn't look like a close call. But when you examine the record and read between the lines in the finding and realize that an infant had been replaced with the father, that speaks volumes. A defenseless infant had been replaced with this father. And to say that he's unfit and fit at the same time is cutting it too close. And those errors were prejudicial to the father. And a different result would have obtained with competent counsel. And I would request that you remand for that new trial.
All right. Thank you, Ms. Koberg. And thank you, Mr. Peterson and Ms. Jackson. We really do appreciate your briefing in this matter and also your arguments today. And Ms. Koberg, please enjoy your son's graduation.
This court is now adjourned.